Good afternoon and welcome to today's presentation, Valuing Economic Damages in Class Action Litigation. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the expert. All materials obtained from this presentation are merely for educational purposes and should not be used in a court of law, sans the expert's consent, i.e. a business relationship where she or he is hired for your particular case. In today's webinar, Ms. Ostrofe will discuss product liability damages, valuation terms, methods for assessing value, typical claims in wage and hour cases, what data economists rely upon, Federal Labor Standards Act cases, and working with your economic expert. To give you a little background about our presenter, Nora Ostrofe has served as a forensic economist for the past 15 years. She has a bachelor's degree in
the past 17 years. Sorry. Keep going.
Thank you. An MBA from St. Mary's College and a certificate in accounting with distinction from the University of California, Berkeley. Attendees who require a passcode, the word for today is economic. During the Q&A session, we ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Tomorrow morning, we will send out an email with a link to the archived recording of the webinar. The slides can be downloaded from the resource list using the widget at the bottom of your screen. Thank you all for attending today, and Nora, the presentation is now turned over to you.
Okay, thanks so much, and thank you to everyone for devoting an hour to this webinar. Just wanted to let you know, in the past, I have not been able to get to everyone's questions during the webinar. So if we don't get to your question, I will be happy to address them individually, and you can contact me by email. My email address is nostrofe, N-O-S-T-R-O-F-E, at hsno.com, or call me at 510-740-0376. Okay, valuing economic damages in class action litigation. I'm going to be addressing two kinds of class action litigation, product liability and wage and hour. I'm going to begin with product liability. But first I'd like to say that class action cases are among my favorite kinds of cases. They tend to be big, meaty cases. They've got interesting questions of value, or in the case of wage and hour, it's an opportunity to work with a statistician on some interesting problems. So this is a topic that I really enjoy. In product liability damages, there's always a very interesting question of value for the economist, in that generally in these cases, there's a product and it has a problem. It's either intrinsically defective or it's not what it's advertised to be, and there's been some sort of misrepresentation to the consumer. And so while we know what the price paid by the consumer was for the product, the consumer was ignorant of the defect at the point of purchase or ignorant of the misrepresentation. So the question for the economist is, had the defect or the misrepresentation been known to the consumer at the point of purchase, what would he or she have paid? And so when you're drafting your sort of claim for these types of cases, your theory of and the measure of damages must be tied to the theory of liability. So when you're filing a case, your theory of liability always has to include an argument for some kind of diminution in value. The consumer paid more than he or she should have. And you want to make sure that that diminution in value is something that is not a theoretical construct, but can be credibly measured by the economist. And often that's a very difficult thing to do. Okay. There's a couple of approaches to valuation legally. One of them, and I'm going to be going through them, benefit of the bargain, price premium, full restitution or full refund. And also a measure of value can be disgorgement of profits, but that is not a legal construct. That's just something that an economist may quantify for you so you can know the profit that the producer made that can serve as sort of a benchmark for what the loss should be, but it's not something that you can make a legal claim about. Okay, benefit of the bargain is a principle that any party who breaches a contract must pay the aggrieved party an amount that puts the person in the same financial position that would have resulted if the contract had been fully performed. This is a good principle. It's very broadly defined. It gives the economist quite a bit of latitude in measuring damages. And I like it because it's not super exacting. If you've got sort of a rough idea of what the damages are, you can claim it under benefit of the bargain. Price premium is a little bit more difficult. That quantifies damages by comparing the price of the defendant's product with the prices of other similar products, and it assumes that absent misrepresentation, the demand for the defendant's product would have been less and the market price would be lower. So for instance, just with the visual, what would a consumer pay for a whole egg versus a cracked egg if they knew they had a cracked egg at the point of purchase? Under this theory, it's a much more exacting theory. It tends to be narrowly interpreted, and you have to really quantify what that difference is between what the purported product was and what the actual product was. And I'll talk a little bit about how that's quantified. But just remember with that one is you're going to have to be very careful that you can really isolate what that difference is. Okay, full restitution or full refund is generally you just refund everything that the consumer paid, take an average purchase price for the product, and everyone gets a full refund. Now, generally, this applies only if the product was arguably worthless or potentially dangerous. And if there is some residual value to the product, very often this particular measurement of damages may be thrown out. A good example that I like is there was a product that was called True Nature Ginkgo, which was sort of a dietary supplement or a new age drug, and it was supposed to enhance brain health and memory. And because that was about the only thing it did, it wasn't a food, it wasn't a beverage, it wasn't something with some use other than that, the court said that if the plaintiffs could prove that the product was ineffective, then it was in fact worthless. But some products, for instance, and we'll go into them, but for instance like a tea that's supposed to have antioxidants or something like that, still has residual value as a tea. And so the product has to be either arguably it's so dangerous we shouldn't be using it all, or it really doesn't have any value other than what the claim is. Okay. Disgorgement of profits, as I've said before, is not a legal measurement of damages, but it can be useful because it's going to be the difference between what the consumer was charged for the product and what it cost the producer to actually make it. And so that's a measure of what it was worth to the producer perhaps to misrepresent it, or a difference between the intrinsic value of the product and what the consumer paid for it. And so it may be a calculation that you want your economist to do just as kind of a sanity check on damages. Okay. Full refund of purchase price is going to be the simplest method because really all you need to do is find out, you'll get all the sales data, take an average and find out what consumers on average paid for it. But again, you must make a convincing argument that the product doesn't have any residual value. Now there was an interesting case in the Ninth Circuit called Pulaski that involved people placing ads on Google, where the court ruled that any residual value after the point of purchase was irrelevant. So even if they got some value from the ads, that didn't make any difference. It's the theory of value is what would the value to the consumer be at the point of purchase if they were aware of the flaw or the misrepresentation. Okay. Under price premium, One way that economists try to tease out what the difference between the price of the product should have been if the flaw or the misrepresentation was exposed to the consumer and what it actually was is hedonic regression. And this is a statistical construct, and it uses statistics to develop an equation that expresses a product's price, which we call the dependent variable, as a function of attributes, which we call the independent variables, by comparing the prices of the product with and without the specific attribute being measured. So one example I thought of is if you had, say, Mexican Cokes being sold that weren't actually made in Mexico. That would be something you could probably easily find using his hedonic regression, because you would just compare the price of premium price paid for Mexican Cokes on the market versus regular Cokes, and since the brand is the same and the packaging is the same and the content is pretty much the same, everything is the same except for the Mexican origin, that would be a fairly easy comparison to do. It gets harder when you get out into the real market and say you wanted to compare Heinz ketchup to another brand, and they come in different packages and they're in different regions, and then it gets much more difficult to tease out what the difference between the attribute you want to isolate and all the other attributes of the product in the market is. Okay. Another example is real estate, where you can fairly easily, say, compare two houses with the same square footage, number of bathrooms, number of bedrooms, but you want to understand the effective location on housing price, and then that's going to be the one thing that's different between two houses that are otherwise the same. Okay. Example in food and beverage. Talked about the difference between, say, a Mexican Coke or a regular Coke. You want the comparators to be as similar as possible in terms of brand, packaging, and so forth, so that you're really isolating. Remember, we're doing price premium, so it's an exacting standard, and you want to make sure that that's the only difference that you're measuring is the attribute that's in question. Okay. Another way for assessing value under price premium is something called conjoint analysis. And it's a little less, I guess, as strong or as less prone to attack. It's a little bit more prone to attack because it's theoretical. And this is where you survey people to determine what the difference in value between different product attributes would be. And very often what you'll do is you'll go to a company, they go out and put a survey on the internet, and they can get relatively cheaply a number of respondents to respond fairly quickly. But this method is sometimes attacked because it's what somebody would theoretically pay for the product when conducted under survey conditions, not when they're actually out in a retail store and making a purchase with their own money. And the other problem is that it's a demand side only. You're not looking at an actual market where producers are willing to produce a product for a certain price and consumers are willing to buy a product at a certain price, and the market price is the price at which they both agree. You're only looking at the consumer side of the equation. So if you're using conjoint analysis, you can expect that you're going to be criticized on the basis that this is in theory only. It's not real marketplace data the way hedonic regression would be. And it's also looking at consumer demand. It's not looking at producer supply. Okay, and here's just an example where if you were looking at various, say you wanted to see what a flat screen TV was worth versus other models, and you'd ask consumers to rank them or assign a relative value to that attribute. Okay, one case which was kind of interesting was a case called ConAgra Foods, and they were looking at vegetable oil. And they wanted to know, they claimed that the oil was claiming to be not using genetically modified organisms, so non-GMOs. And the question was, what was that attribute really worth? So they used hedonic regression to just find out what the 100% natural claim was, okay? And they isolated whatever that was worth, say, 25 cents or something. And then they used conjoint analysis to determine the percentage of the value of the 100% natural claim that was attributable to the absence of GMOs. So you can see when you're using the price premium, you get into these fairly specific, exacting questions that you need a lot of analysis to get to. And that was accepted by the court, that methodology, but it was attacked by economists as unreliable because the regression analysis, as I said before, it was kind of apples and oranges. Regression analysis was conducted in the actual marketplace with both supply and demand, but the conjoint analysis was theoretical only, and then they didn't look at all the other attributes such as price, brand, and packaging the way you could have with regression analysis. Okay. And in full restitution, again, this is usually very easy if you can make an argument for it. You just need to find sort of the average price paid by consumers, and then that's the price you'd be refunding back to them. Okay, common pitfalls in using valuation methods. And you really want to think this through before you begin your analysis because they're expensive to conduct and it's easy to be shot down. Okay, must be reliable. Okay, and we've talked a little bit about how certain models can be attacked for being unreliable, and they must be able to accurately measure damages across the class. Okay, reliable means that the damages model must measure only those damages attributed to the defendant's allegedly misleading conduct. So again, it has to be linked to your theory of liability. You can't be measuring something else, and we'll look at an example of that in a moment. Okay. Must have a sound methodology, okay, or the predominance requirement isn't satisfied. Okay. Benefit of the bargain, one of the pitfalls would be failure to accurately quantify the amount that would put the consumer in the same financial position that would have resulted if the contract had been fully performed. Okay. This was kind of an interesting case. It was a case about light cigarettes, and the court did not find the plaintiff's damages model convincing. And the reason why is they came up with sort of a large measure of damages that the court interpreted as restitution, not benefit of the bargain. And when they conducted their study, they found out that after people who bought the light cigarettes discovered that light did not necessarily mean safer, they continued to buy the cigarettes at the same price because they valued other attributes more, such as taste and smoothness and so forth. And so it was clear to the court that even though they had used conjoint analysis and theoretically measured what the value of safety or light cigarettes or less carcinogenic theoretically meant to the consumers, in the actual marketplace, the consumers didn't really care whether the cigarettes are safe or not. They just continued to buy them at the same price. And so the damages model was thrown out. So again, you really want to think through your damages model and make sure that you're quantifying the right thing. In this case, it appears that light cigarettes or the safety attribute had no value at all to the consumer. So you might have wanted to look at pricing data after, whatever the supposed misrepresentation is to see if the price changes before you get fairly deep into the case. Okay, hedonic regression model. Very often, this will result, too, as you commit yourself to a hedonic regression model, which makes sense in theory. We can use that to isolate what the price of the product should have been. but it's impossible as a practical matter. For instance, there are no comparators that exist in the market. There isn't an identical product without the feature in question to determine the value of the contested attribute, or there's so many variables that affect the product's price that it's impossible to isolate the value of one particular variable. So you want to think through your damages model and make sure that it's something you can actually do. If not, you might want to go to another model, such as full restitution or benefit of the bargain. This was the case in a case, Twining's green tea case, where ever since they had introduced the green tea, they had claimed that it was an antioxidant. In this case, the claim was that the tea didn't have any antioxidant properties, and they were going to run a regression model to find out what the antioxidant claim was worth to the consumer, but there were no green tea products that didn't have antioxidant claims, so there was nothing to compare it to. So when the economist went to actually conduct the Hedonic regression model, there was no way to do it. So the model was unusable. Okay, full restitution or full refund. Again, you have to prove that the product is legally worthless and has no residual value. This may be impossible to do unless if it's just a deceptive or misleading statement about the product, because the product may have some kind of residual value. May be appropriate for products that have been recalled or constitute a danger to consumer or is subject to recall if it can be credibly argued that the potential damages to the consumer outweighs any residual value. I did a case involving a defective hairdryer that had the potential to ignite or throw out hot coils that could hurt people and so forth. And in that case, we argued for the full restitution under the theory that even if the product didn't manufacture, it didn't malfunction every time it was used, it had the potential to, and therefore, like a chicken that was potentially infected with salmonella, it was so dangerous that it shouldn't even be attempted, and there was no residual value. So there was an argument for that particular model. This was another green tea case where the plaintiff contended that the product was legally worthless, again made an antioxidant claim, but because there was a residual value just on the basis that even if it didn't have antioxidant properties, it could still be enjoyed as a tea, it did have some residual value, and so the full restitution model was thrown out. Okay, some tips on estimating damages. So when you are coming up with your theory of the claim, you really want to think carefully about the actual loss to actual consumers. You want to consider the value of all the product attributes purchased by a consumer, including convenience, luxury, taste, signaling, style, anything you can think of. You want to look for actual market price comparisons that imply premiums for the product attribute that you're interested in. You want to consider all available methods for estimating damages. You want to potentially claim every methodology you can, so if the court throws out one, you've got another one in your back pocket to pull out and use. Okay. Market prices aren't available on all relevant product attributes. If they are available, that should be the dominant indication of consumer losses. You want to use market data, not theoretical data, whenever possible. You want to show that damages can be reasonably determined on a class-wide basis, and that your damages proof is tied to the specific violations alleged in the complaint. Links to your theory of liability. You also might want to consider what you do if your claim is balkanized. Again, in the hairdryer case that I was working on, we had all this national data, and we filed our claim. And then what happened is we were certified, but we were only certified in 2 states, New York and California. And then we found out that we only had national sales data, and we didn't really know how much product was sold in California and New York. And we had to do that in order to find out what the damages were. And interestingly enough, there were absolutely no sources of data that would tell us how many hair dryers were sold per state. So we eventually had to go to government data, which told us on a very broad basis what percentage of personal care products were sold per state, and we ran with that. But if you think that's a possibility, that's something you may want to think through and get the data on in advance so that you have it if you only prevail in certain venues and not others. Okay. Questions on product liability?
Now you're entering the Q&A. Please remember that if you are applying for CLE credit, you must attend for the full 60 minutes of the presentation. Please enter the passcode during this time. The passcode is economic. You may also enter any questions that you have for Nora. First question that we have is, what about claims for full restitution value when the product has failed only a fraction of times? What about the residual value of the product for all the consumers for whom the product didn't fail?
Okay, well, it depends. If I was on the plaintiff's side, I would stress the potential to fail and whether or not the consumer would consider whether the product had any value if he or she knew about the potential for failure at the point of purchase. For the defense, I would stress the large percentage of products that haven't failed to date. And also, if there have been any notifications to the consumer of the potential for failure, if it's caused any diminution in the product price, or you may want to show that consumers have continued to buy the product after being cognizant of the possible failure.
How can any product be worthless?
Well, I think if you're looking at it from the plaintiff perspective, you might want to say that at the point of purchase, if the product has a problem, it's not worth the time and trouble to purchase and then have to replace. Defending, you always kind of want to look at the residual value. So you might want to say the product must have some intrinsic value as measured by its cost to produce it. Obviously, somebody wouldn't bother to produce it at all if it was really intrinsically worthless, and say that full restitution is always an overstated value.
What should I look for when reviewing experts' reports?
Actually, in both product liability and in wage and hour, first thing you want to look is, does the basic theory of loss make logical sense? If not, you want to ask yourself what is wrong with it. Second thing you want to look for is any assumptions. What is assumed and what is supported by hard evidence, and break these two out and quantify them. What are the gaps in the data? There's almost always gaps in the data. You want to look for those and sort of see where the soft spots are. Ask yourself, when findings are extrapolated to the entire class, does the final number seem reasonable? Does it seem too small? Does it seem like it's overreaching? Are there mathematical mistakes? Are there errors in applying the penalties or the statute of limitations? Is the theory of loss and the calculation of damages simple and straightforward? The more complex they are, the more you're probably relying on assumptions, the harder it's going to be to explain to the finder of fact, the more possibility there are for errors. Another thing I've seen is, do the damages depend more on the expert's supposed expertise than logic and common sense? It's always best the simpler, more straightforward, easy to explain your damages model is, the easier it is. As I've pointed out, some of these methods like hedonic regression and conjoint analysis get more and more and more theoretical and complicated as you go on, and those are just easier damage models to attack and harder damages model to explain.
Okay, thank you. Continue on with your presentation.
Okay. And I'm going to go on to wage and hour class action cases. Okay. Typical claims. Probably everybody is familiar with these. Unpaid wages or wage theft, which would be unpaid overtime, work off the clock, unpaid commissions, bonuses, gratuities, travel times, violation of minimum wage statutes, federal and state, meal and rest break violations, misclassifications, or final paycheck not received. Okay, typical penalties in wage and hour cases are waiting time penalties, wages weren't paid at termination, penalties for unpaid overtime, missed meals and rest breaks, liquidated damages, which would be damages based on what wages weren't paid that should have been. You can apply prejudgment interest. And then in California, we have the Private Attorney General Act, which would be $100 for every initial violation and $200 for every subsequent violation, which really makes penalties add up quite a bit. Generally, wage and hour cases sort of are frequently missed overtime, 40% of allegations in settled cases. Okay, data that economists are going to rely on to value claims. Anecdotal data is kind of harder data to work with, but you can rely on plaintiffs' allegations cited in their complaint, depositions and declarations of class members, surveys of class members. Employer data is always sort of a good data to rely on. We'll have payroll records, pay stubs, W-2, wage and tax statements, tax returns. You don't have the W-2s, depositions of persons most knowledgeable. That'll often be the person from HR or the person who's responsible for payroll data, time clock records, punch data, when the employee's punched in and out. Sometimes if we don't have punch data, we have alarm systems records when we can tell when employees were entering and exiting the workplace. Videotapes showing when employees were on work. Phone records, which show when employees were working. Time record edits, sometimes if the employer is fraudulently altering time records, that will be apparent in the edits. And shift reports. You can also rely on employer documents such as an employer handbook, written company policies that may be facially invalid, employment contracts, or collective bargaining agreements. Okay, ideally, again, the ideal case is that violations are going to be explicit in firm documents. Otherwise, you're going to have to calculate values based on assumptions or anecdotal data. And that's very commonly the case with rest breaks, where employees don't punch in and out to take them. So you sort of have to rely on what plaintiffs said about whether or not they took their rest breaks and an assumption. In terms of data analysis, wage and hour cases can be expensive to do. Probably the most efficient way to do it is electronic programming. If you can get a copy of the employer database and then program it to identify the violations, that's optimal, but often that won't be produced. And so you have to go to actual data records on paper, or if you can get them in a spreadsheet like Excel for easier manipulation, that's helpful. But in a lot of cases, we've just got time cards and pay data in PDF format, which requires them to be input and then analyzed. If that happens, statistical sampling can be a less expensive way to go, and in that you don't, say you have a class of 300 or 400 employees, you can sample a subset of employees and then calculate the number of violations and then statistically extrapolate that to the rest of the class members without having to look at everyone. And if you don't have any data at all, or the data is really problematic to work on, you can construct a model based on theoretical assumptions. If we had this many people and this is the average length of time that they worked, we assume that this would be the number of meal and rest breaks and overtime they would have worked. But again, that's not based on hard data. I was once in a position where I had to do that because we had a week to file, and we had just been given, I remember I was sitting in the dentist chair, and I got a phone call that we had to analyze 1 million documents in a week, and I'd just been telling the dentist this is the only place I can relax, and then I get this phone call. So we tried to see if there was any way to do it. We just decided it was impossible, so we constructed a theoretical model and filed the motion, and then said, we'll supplement it when we get a chance to go through the data. So that's always an option, but it's not going to be based on any real data. Okay, challenges in data analysis. Class action cases can be very messy, and they usually are. Very often, if there is an employer with alleged violations, they're not necessarily the best record keeper either. And so you can have missing employee records, handwritten or legible employee records, voluminous records, just way too much data and too little time to go through it. Very disorganized records, conflicting records, which is hard, where the time and the punch data don't agree and you're not sure which is right, or very complex data. I had a class action case involving nurses who had like 3 or 4 different pay rates and shifts that could go for 24 hours, and that was difficult to work with as well. Statistical sampling, if you're using that, sometimes you don't have enough data. You usually don't know how many people you need to sample until you've run statistics on an initial group and you've looked at your margin of error and how valid your statistics are. And you may not have analyzed enough people, and then you have to add people to your sample as you go on. So that can be a problem that arises, or the data may produce fewer violations than alleged, and you don't really know that until you go through your entire analysis, and then you sort of have to figure out what to do. Another challenge can be that your case is filed in multiple venues, and so you've got different violation rules and violations and penalties. Did one that was a FLSA, California, Illinois, and New York case, and so every subclass had to be treated differently, which represented a challenge as well. Okay, FLSA cases would generally either be failure to pay minimum wage, which is $7.25 per hour, a failure to pay overtime, which is 1.5 times regular rate of pay after 40 hours of work in a work week, wages not paid, it's supposed to be due on a regular pay day, and deductions for work-related expenses will be illegal if they reduce wages below FLSA minimum wage. So in an FLSA case, we're usually looking at the data and seeing if any violations of these requirements occurred. Okay. There are some exemptions from FLSA overtime provisions as salaried employees if they're earning about $47,000 or over, commissioned salespeople, certain computer professionals, farm workers, and certain drivers. Okay, I've seen cases where employees were misclassified as commissioned salespeople to get around the overtime in order to not pay overtime and claiming that they were exempt, and we had to go back through the records and determine what they should have been paid because they were misclassified as salespeople. So, and in this case, all 3 requirements in order to get the overtime exemption must be met. The employee must be employed by a retailer service establishment. Their regular rate of pay must exceed 1.5 times the applicable minimum wage for every hour in a work week in which overtime hours are worked, and more than half of their total earnings must, in a representative period, must consist of commissions. So sometimes what we'd be asked to do is go in and look at that and make sure that those requirements applied. Okay, working with your economic expert. Wage and hour cases, once you get all the records and you're analyzing them, it's very, very hard to turn on a dime. So because we have to line up the data a certain way, and now we're looking at lots of employees, and then we have to turn the data over to the statistician for analysis and so forth. So in these cases, you want to review your economist is probably going to be working off your complaint. And as the case progresses, the attorney may be dropping certain claims or adding claims and so forth. So you want to review the allegations in the complaint with your economist right at the inception of the case. And if you're departing from the allegations in the complaint, you want to make sure that you tell your economist immediately so that they can adjust their analysis to what your current claims are. I've had cases where I'm just about ready to get the report out the door, and all of a sudden somebody says, oh, we want to do this, and it's very, very hard to do that in a short amount of time. So make sure that you're always working step by step with your economist. You should have your expert involved in the discovery process at the inception of the case, especially if you're going to do statistical sampling, so that you make sure that everything you're asking for and that the employees, if you're going to do a sampling, that they're randomly selected, that you've selected enough employees to do statistical sampling and so forth. Have them involved in the discovery process and make sure that they get all the data that they need. Okay? Do not take statistical advice from anyone who is not an experienced forensic statistician. I cannot emphasize that enough. Cases have been thrown out in court because the judge made a mistake in the discovery process by making a ruling that is not in accordance with statistical methods. So do not take statistical advice from another attorney, a judge, a colleague, opposing counsel, another expert. Anyone who's not a statistician, they may not know what they're talking about. Okay, here's the very happy economist. This is someone whose attorney is working with them. If as you're going through discovery, you decide you need to depart from your original claims or allegations, let your expert know immediately. This is important because wage and hour cases can very easily get out of hand in terms of costs. And when everyone's under pressure to go ahead and get everything done for motion for class certification, it's easy to run over budget. So plan and budget your case and scheduling, but assume wide margins for errors and unforeseen developments. Because all those things can dramatically expand the amount of time and money needed to complete the analysis. You may also want to consider how you're going to pay for everything should you lose or not achieve class certification. Don't financially extend yourself beyond what you can afford to pay if you're not successful. Try to do the minimum amount of work possible to achieve class certification. Again, because it is so costly, you always want to do the minimum amount of records that your statistician will say will result in a reliable answer and nothing more, because everything is expensive to do. Okay? If you're on the defense of these cases, you should pay attention to the hard analysis and ignore anecdote. Okay, statistically speaking or mathematically speaking, the plaintiff's analysis may be very flawed. I've worked on the plaintiff's side and seen a lot of defendants settle without taking a hard look at the actual data. So you want to look at the figures and retain a statistician and an economist and find out what the flaws in the plaintiff's analysis are, or weak spots, for instance, rest periods. Very seldom, rest penalties very seldom can be proven one way or another, and quantify that for the allegations that are not supported by hard data. How much are they worth? You may want to consider deducting that from the final number. Okay, just a few cases here where statistics came into play. Duran, this was a case where when the judge was going through discovery, he selected a sample pool of employees to be analyzed that wasn't statistically valid. It wasn't large enough, and it wasn't random, and then ended up that the results and the damages that resulted from the statistical analysis had to be thrown out. Okay, So again, this was the judge's failure to consult a statistician when he was making discovery decisions. And so that's a real reason where if either you're going to be doing statistical sampling or the other side is going to be doing statistical sampling, the statistical requirements have to be stringently carried out from the inception of the case, because everything's going to, in this case, they picked the wrong employees to analyze, and so everything down the line had to be thrown out. So you have to be very, very careful when you're doing statistical sampling. Tyson. This was an interesting case. This was involving donning and doffing, and it was an expert who these were meat workers, and there were cut and retrim workers and kill department workers, and they would get dressed in their gear to work, and this wasn't counted in the time that they were paid. So they wanted to find out if there was missed overtime because employees weren't paid for the time that it took for them to get into their work gear. And since they hadn't punched in when they were donning and doffing, there was no way to measure how much time it took them to get ready for work. So the plaintiffs hired an expert, and the expert said, for the cut and retrim department, it takes them about 18 minutes to get into their work gear, and for the kill department, it takes them 21 to 25 minutes to get ready for work, and we're going to look and make sure, see if they had any unpaid overtime, because the time that it took them to get ready for work wasn't counted. So, so since there wasn't any punch data that would tell us exactly how much time it took on average for the class to don their work gear, they hired an expert, and the court accepted the expert's estimate of the average amount of time. Now, the plaintiff bar heralded this case as allowing representative evidence, but the court did say that the case presented no occasion for adopting what they call broad and categorical rules governing use of representative statistical evidence in class actions. So it didn't make it wasn't a broad acceptance of using representative evidence, but it was an example of a case where representative evidence and not hard data on the entire class was accepted in order to determine damages. And $2.9 million in lost overtime was awarded in this case. Okay, Vaquero. This was a case involving a company that required sales associates to perform a lot of tasks unrelated to sales and didn't pay for this work beyond what was earned in commission. And the court said that even though the damage calculations might have been individualized, this didn't defeat class certification, and they could file the case as a class. Okay, and Walmart was an interesting case. This was another pitfall of statistical sampling, where the court, essentially the claim was that across the board, Walmart discriminated against promoting female employees when compared to male employees. And essentially the court didn't believe that it was plausible that all Walmart managers could be involved, could be similarly biased across the class, even if the plaintiff's statistical evidence and anecdotes suggested this. So the court basically didn't believe the premise and felt that there was problems with the statistical evidence. Okay, we've got about 12 minutes for questions on wage and hour.
We are entering the Q&A. Please remember that if you are applying for CLE credit, you must attend for the full 60 minutes of the presentation. Please enter the passcode during this time. The passcode is economic. You may also enter any questions that you have for Nora. Our first question is, what assumptions do you make for rest break violations, which are generally not captured by employee time cards?
Well, when I'm working on the plaintiff side, the instruction is always to assume the maximum number of violations. So it's like every 4 hours worked, just assume a rest break, which of course maximizes rest break allegations. But I would say if for the defendant, you have to ask yourself, is it really plausible that no worker across the class at any time ever took a rest break? And so I'd look over the anecdotal data or just try maybe sample data workers and survey them and ask them what the actual frequencies of their rest breaks were and incorporate that into the analysis.
Next question, what if employee time and pay data is available only in PDF format requiring extensive data input?
Well, you've got some options, and I've been in this situation. It's difficult and it's expensive. One time what we did was we tried to OCR them and take it in, convert it electronically from the PDF format into Excel, which you could do, but then we had to, it wasn't ready for analysis even at that point, and then we had to manipulate in Excel, and it ended up taking as much time as data entry. So that's a possibility, and it could be that your records are, if you OCR them or convert them, are in an easy format, and you can do that. So it's something to look at. You can offload data entry to a subcontractor. That doesn't charge very much per hour for data entry. The firms I've worked with generally don't want to do that because a lot of this stuff is sent to India, and they're worried about compromising sensitive information like Social Security numbers. One thing you can do is have the damages expert create a template, and you could have admin people in your firm or hire admin people to do the data entry. And then all your damages expert really would have to do is sort of check for accuracy and then analyze the data. So that's another option. Usually most economist firms will do the data entry for you, but it's going to be at a premium rate, so it's expensive. And then what you can do is consult a statistician, but this is, again, a reason for having a statistician on board very early, and just find out what the smallest number you can use as a sample is, and just input that sample and then extrapolate it to the class through statistics.
What data do you normally suggest your clients obtain?
I would go back to, well, basically, let's go back to when I had the slide on common data. I'm going to go back there. Hang on just a sec. Okay. You're going to want payroll records, pay stubs, earnings statements, depositions of persons most knowledgeable. You want time clock records or punch data. Anything else in the workplace, any kind of workplace records that's going to show when the employees were there and working. Often your named plaintiffs can give you a lot of information about what data is available. Or you can get declarations from class members if it's off the clock time about what they did. I've seen a couple of gym cases where there were videotapes that were showing off the clock time or how long people were actually on the work site. There would be employer documents. Usually there's kind of a discovery battle about how many employees the defendants are going to release data about. They're always, defendants will generally claim, and with some justification, that producing employee records, for a number of years back for 500 employees is very burdensome. So again, this is a good reason for both sides to be working with statisticians to come up with a reasonable number of employee records to produce. And what you can say is, we'll produce X number of employees to start, and then if you need more data, we can do a subsequent production. But you may want to identify, because you have to do random selection, you're going to have to randomly select from the entire class. So you're at least going to have to look at everyone in the class and pick a subset. Usually what we do is we just assign a random number, let's say between 1 and 500, and then we start with the top 50, say, and then if 50 isn't enough, we take the next person off the roster. But that's why you want to get a statistician on board if you're going to be doing statistical sample early on, because you have to select the employees to be sampled at the inception of the case as you're working your way through discovery.
That's all the questions we have. Could you possibly wrap up the presentation in the next 5 minutes?
Actually, I'm done.
Could you possibly expand more on the wage and hour half of your presentation?
Sure. Okay, if I were, I guess, in an ideal world, I'm going to talk about how I would address a wage and hour claim. The first thing that I would do if I were starting out is I would get a copy of the complaint, discuss it with the economist, what claims I'm going to make, and I would retain a statistician. I would then, my next step would be determine if I wanted to do statistical sampling, is determine or get a rough idea of the minimum number of employees I wanted to sample. I'd then, and this would be if I was on the plaintiff or the defense side. On the defense side, I'd be looking at the sort of the reasonable number of records I need to produce. And having a statistician's declaration to determine what the reasonable number is. Then, if I were on the plaintiff side, I would, try to get all my records. I'd try to get maybe sample copies of the records for a few employees in order to look at the quality of the data and what the gaps of the data are, and also determine what challenges there are going to be, or if there's alternate data. Usually, if you're the economist and you get all this data and all of a sudden you're working your way through it and trying to figure out what the problems are and how you're going to address it, and by that time you're usually on the clock. So I think looking at the data, both parties, defendants and plaintiffs, looking at the quality of the data and what data are the violations going to be explicit in, and what data don't you have? You don't have data on rest breaks, you don't have data on off-the-clock work. What are the assumptions that are going to be made? That's going to tell you sort of what violations are going to appear in black and white, and then what violations are going to be based on assumptions. And already, as you're starting to quantify that, you're going to have a better notion of kind of what the challenges in the case are going to be for both sides. What is kind of incontestable and what is going to be open to anecdote and assumption. Usually, defendants are in a position to do a couple things. If they have an employee database that they can manipulate, they can often run the data on every employee and find out what the number actually is, as opposed to the plaintiffs, if they aren't if they aren't presented with all the data, they can only make guesses based on statistical sampling or a subset of employees and that sort of thing, and can be attacked for extrapolations instead of this is what it is for everyone. I would look once reports have been produced, actual damages reports, I'd look very carefully at them and make sure there are no errors, flaws, overstatements, understatements, and so forth. I think we are got 45 seconds to go.
Okay, thank you, Nora.
Okay, thank you.
In addition to being your best source for testifying and consulting experts for the past 60 years, TASA also offers e-discovery and forensic solutions, free interactive webinars, day-in-the-life videos, research reports on expert witnesses such as the Challenge History Report 2.0 and Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Ms. Ostrofe for her time and effort in creating this presentation. If you would like to speak with Nora, or if you would like to speak with TASA representative regarding an expert witness for a case that you are working on, please contact TASA 1-800-523-2319. One of my colleagues will be following up with you regarding your feedback on today's presentation. This concludes our program for today.